day to all the viewers at home, and welcome to a new thing brought to you by the Global Business Roundtable. My name is Sipho Mseleku, the convener of the Business Roundtable and your host for today. The Global Business Roundtable, also known as GBR, is Christ-centered organization. GBR is multi-denominational, multicultural, and multiracial organization focusing on the holistic development of its members in line with God's purposes for their lives. GBR focusing on the kingship of Christ and not only on the priesthood of Christ. It encourages its members not only to influence and take over the spiritual mountain, but also other sectors of society, such as education, economy and finance, science and technology, sports, arts and culture, politics and governance, and also deals with family and societal issues. The name of the show is taken from the book of Isaiah 43, verse 18 to 19. Forget the former things. Do not dwell in the past. See, I am doing a new thing. It springs forth. Do you not perceive it? Now I'm going to introduce our panel, panelists who are going to give us more insight on today's topic. On my extreme left, I have Miss Nadia Armin Randals. She's a legal advisor. Next to her, I have Mr. Alex May. He's a director at Alex May Incorporated. On my right, I have Advocate Limpho Maema. She is an advocate of the High Court in Lesotho, and she's also a GBR special envoy to the convener in Lesotho. On the extreme right, I have Miss Yolisa Ngxabazi. She's a director at Ngxabazi Attorneys. Welcome to you all.
Thank you.
Before we start our program, I think I would like to give you a few minutes to just briefly introduce yourself, to tell us about what you do, your highlights, and any other thing that you think is will be a great information for the viewers. Let's start with you, Miss Nadia.
Good day. My name is Nadia Armin Randals. I'm currently a legal advisor at Alex May Incorporated and will be admitted in March. Our firm deals mainly with commercial law matters and family law matters. And yeah, that's all about me.
Thank you very much.
Thank you.
Let's hear from you, Alex.
Thank you. My name is Alex May. I'm a director at Alex May Incorporated. I have been practicing now for 21 years. We are mainly dealing with commercial law, contracts and family law.
Thank you very much. Thank you.
Good day, my name is Limpho Maema. I'm a lawyer and a development consultant, and I focus mainly on project management and social inclusion.
Thank you very much, Your Excellency.
Good day, I'm Yolisa Ngxabazi, a director at Ngxabazi Attorneys. We are a Black woman-owned law firm offering in-house legal support to small, medium, and large businesses. We offer a range of expertise ranging from legal risk management, negotiation of contracts, arbitration forums, and litigation. Thank you.
Thank you very much. And I think your background is quite useful for the questions that we will ask today. And the viewers are highly expectant that you'll be able to assist them with the legal issues that they face every day. Just to get straight to the point, can you define a contract for us? What is a contract? Why do people enter into contracts? Are all contracts binding? And what makes all contracts binding? What does a contract consist of to be binding? What makes a contract binding? And how can people get out of the contracts if they feel something is not right with a contract? And then give us examples of contracts that people sign every day. So who wants to start?
I can start, no problem.
Okay.
Well, a contract is essentially, normally it has to be between two parties. The parties has to be consenting. And one has to make sure when a contract has to be in writing and when it has to be witnessed. So those are all very important elements. I can maybe give a brief example. I acted for a petroleum company where they entered into a merger with a French company on gas issues, and 2 years later they have not been able to sign a written agreement. the circumstances of the company that I acted for changed, and they decided not to proceed with the merger. However, at that stage, they have already handed over about 140 million rand in assets, and the party who received the assets was actually making a large profit from that for the past 2 years. I brought an application in the High Court, and the matter was settled, and the party who received the gas assets accepted that eventually that because no written agreement was concluded, that he was not entitled to proceed with the business, and that my client had the right to cancel the contract. So it's very important when you enter into an agreement and agreements exchange on the basis that it will be signed, and there's clauses that says that it will be signed, that you make sure that you get something in place and that you get it signed, so that you don't end up in the position where you actually run a profitable business, where you have invested a lot of time and money in that business, and you end up with the other party cancelling the agreement validly and legally.
So, for your own protection, it is advisable to have a contract reduced to writing. So if it's not reduced to writing, you may face difficulties in enforcing it at some point in time. Is that what you're saying?
Absolutely, sir, because the problem is that if you don't reduce it to writing and litigation ensues, then you would have to rely on a lot of external evidence and verbal evidence, and it will be costly to prove that you have a contract and what the terms of that contract was. In this case, for instance, we had to fly to New Zealand to go and get evidence from people who has already left the petroleum company. So it's a very important point that you are making, sir, that it's the best thing to have it reduced to writing, to have it signed, and then the parties know where they are standing. You'll also find that the best clients are normally the ones who actually sign contracts, and they are best protected. Absolutely.
So in brief, you're saying a contract can be verbal, but it becomes difficult to enforce and becomes more expensive to enforce. But it's acceptable in law to have a verbal contract, a verbal agreement amongst parties. Yep.
It just makes it a lot easier on everybody if they know exactly where they're standing. Parties often enter into contracts where they don't, they think they understand each other, but they don't. And as a consequence, lawyers make a lot of money.
Yes. Okay, anyone who wants to come in there?
I think what is important is a contract is aimed to record what the party's engagement is. And that is because you need a document that confirms what we've agreed upon should at a later date have differing views. But what it also adds is, at times when we engage from a verbal agreement, not reducing it in writing, we do not contemplate what could potentially go wrong. And should you decide to pull out, what is the mechanism that we will engage in the event that you want to pull out? Or should there be certain remedies or enforceability that we want to enforce? What mechanisms do we have in being able to say, you didn't deliver according to what we agreed upon? So having a document referring back to what did we agree upon as part of our engagement is quite important.
So it's very important that a contract is specific, entered between two or more consenting people.
Yes, absolutely.
And specifying the terms of the contracts.
Yes, and one of the questions you asked was, how do you determine whether this would be a binding or a valid contract?
Yes.
Is that you look at a few elements that are prescribed in the law, that the parties, there was an offer and acceptance between the parties. One made a proposal, the other one accepted, that there is legal capacity, which is quite a crucial thing, because if you are a minor, you can't enter into a valid contract. If you have a mental disability, because you do not comprehend. And what is also critical was the issue of consent, because you needed to have consented to the signing, which is where the signing is important. But sometimes the consent has to be informed consent, because you have to fully comprehend what you're engaging with, your rights and obligations under that contract. It has to be legally enforceable, in that you acting under the contract is not breaking the law, and whether you can enforce your rights under that contract in terms of legal mechanisms available, such as courts and whatnot, and whether the possibility of performance, are you able to carry out what is being asked in this contract from a possibility of performance as well.
Okay.
So those are just determining how a valid contract would exist.
Your Excellency, you want to come in here?
Yes, Your Excellency, thank you. I think also it's important to note that in the context of day-to-day life, we do get into implied contracts. And that's the kind that is most common between members of the community, where based on assumptions and based on from conduct and our relationship, it would be possible for a contract to arise. So I think even in that context, it's possible to have a valid and enforceable contract, even though it would be implied.
Implied contracts, that's a very interesting concept, that through your conduct, you may have committed yourself into and that's a very, we'll get into details on that because maybe you'll need to give us some examples of the implied contracts. Nadia, do you want to come in here?
Yeah, I think the panel has basically said everything. I just wanted to extend on what you said in terms of being informed when you do actually sign a contract and you know what you are signing and you are aware of the termination clauses, your exit clauses, what happens if I do not perform, what happens if somebody else does not do what they have to do, how do I enforce my rights? So also besides just signing, I think you have to know exactly what you are signing. And a lot of people sign contracts and say, I did not know what I was signing, or I was under duress. So it's also being aware of what you are signing and often going the extra step and just finding out what does the contract mean, going to a lawyer or going to somebody else and just getting the know-how so that you know exactly what you are signing. So you cannot fall back and say, oh, but I did not understand, I did not know.
But most people do not read the fine prints.
They don't read the fine prints.
Especially when they enter into contracts such as hire purchase agreements, when they want to buy a car, want to buy some assets, they quickly want to enjoy those assets, and then they neglect looking into the fine prints, which has terms and conditions. They just sign, and later on they find themselves in trouble. But you've also mentioned a very important word, duress, that you have to fully appreciate what you are signing. And if you're signing under duress, what happens to the contract? Is that contract enforceable or is it voidable?
If you are signing under duress, it is voidable because you're supposed to have consent when you are signing. It's supposed to be voluntary when you are signing. So if you are pressured or if you are under duress, then the contract will be voidable.
What is duress? Duress
is when you unduly pressured into signing. If somebody puts a gun against your head and says you better sign, you better sign the sale agreement so that your house can be sold. That is duress. Or somebody says I will not pay you if you do not leave the company and sign, termination of employment.
Yes.
We will not pay you. Things like that. That is when there's some sort of pressure, external pressure on you and forcing you to sign a contract that you initially would not have signed.
If you were.
If you were doing it voluntarily.
Voluntarily. Okay. Your Excellency, you were just talking about the implied contracts. Can you give us some example?
Okay. A typical example would be when maybe I come to you and explain my situation, whether a financial difficulty, and you lend me money without me having said outright, please lend me money. And later on, that would be binding because through my conduct and statements, I would have given you the impression that I'm actually requesting you to lend me money. So that would be my binding. At a later stage, you can actually claim the money if now you start having problems recovering the money.
Okay. Now, thank you very much for that clarification. The second question I want to ask is about the typical examples of the contracts that people enter. They sign lease agreements, whether for property, which they lease as homes, apartments, townhouses, or buildings, office space, but also they sign agreements for equipment, furniture for offices. What is it that people need to look for when they enter into lease agreements?
Happy to go.
You want to come in?
I think what has to be very clear is the lease amount.
Yes.
Is the duration of the lease.
Yes.
It's the property being leased. Yes. And whether there are defects to that property, which has to be listed before you use the asset. and what are the terms of termination in the event that you want to exit that lease agreement, and in the event that you do not pay your monthly rentals, other penalties for failure to pay, late payment, and what are the terms of you receiving, if there are grounds for deposit payment, what would be required for you to get your deposit back. I think that's crucial.
Those are the key things that people should
Absolutely.
look at, because there are implications on default.
Absolutely.
Yes. Yes, Nadia.
I also think you must look at whether there's a maintenance program. If you are leasing, let's say, a photocopying machine for about 5 years, obviously you're using paper, it prints paper constantly, and your office won't be equipped to maintain it should it break or should anything happen. So what is the maintenance that will be provided with that lease period? Same if you are leasing a house or any building. Are you allowed to do any maintenance? Are you allowed to do any renovations?
Yeah.
So you need to also have a look at that and discuss that with your landlord and make sure that you understand what those terms and conditions are.
So when you lease equipment like photocopying machine, printers, you could find yourself with a bill of hidden costs that you were not aware of. So you need to be able about the cost of the maintenance and service and the paper.
Yes.
That is not just a machine.
Yes.
And that's a very, very important point. And then also, what happens when you renovate a building? Can you claim that money back from the landlord?
From the landlord, yes.
If you've renovated somebody's house or property at your own cost. Say the lease has expired and you have to get out. What happens to the money you've spent?
Yes, well, if I can pick up on, sorry, Nadia.
You can.
Yes, it will be determined by what your contract says. Sometimes the landlords will specify that you are not allowed to improve on the property. It will depend on whether your contract has a so-called non-variation clause or not. That means that the contract cannot be amended unless it is reduced to writing and signed by both parties. In the absence of such a clause, and let's say you are renting a house and you have renovated a bathroom and you actually have no written agreement in place, then in terms of our common law, you would be able to claim the value of those improvements that you have done to the property. But first of all, it's very important to determine if there's a contract or not that is in writing and whether it has been signed, and exactly what the terms thereof is. But in terms of the common law, you can certainly claim for those improvements, yes.
Okay. Do you have anything to say here?
Yes, Your Excellency. I think it's also important to consider the risk allocation and liability waiver clauses within a contract, because normally, in terms of risk, the risk is normally borne by the party best positioned to do it, but sometimes it works out otherwise. If you need to take out insurance, it would be an additional cost, so there's an issue of affordability right there. And in terms of liability, you also have to be certain what you're responsible for and what the landlord is responsible for, and try as much as possible you can negotiate in order to limit. If you cannot negotiate or limit, then explore ways in which you can reduce the risk. Okay.
Interesting. There's another dimension. I think we'll take a break and then come back and discuss the hire purchase agreements, because people enter into those agreements every day, buying a car, buying furniture, buying all kinds of assets on hire purchase, and the cost of finance for those. You find that an asset that would normally cost, say, 2,000 Rand or $2,000, suddenly by the time you finish, you've paid 6,000, and people don't check the cost of finance of those purchase, and most of the time they don't look into the implications. What do these agreements entail? And the second part also is to look into the partnerships agreement, the agreements that lawyers, doctors, professionals enter every day. Are they binding to other partners? If one partner signs and other partners are not there, what are the implications of that? And you can just elaborate on those. Who wants to start? On any? You want to start? Okay.
Yes, I think with hire purchase, the most important thing is that ownership does not arise immediately. Usually it would involve a a customer making a down payment and paying over an agreed period of time a certain amount of installments, and until that property is paid off, it belongs to the seller, not the customer. So sometimes you find that issues of ownership, if one defaults and they try to repossess, you find someone was under the impression that they own that particular, or at least they have some level of entitlement because they've been paying. So I think that is very important to take into account the risk and whether you can afford to enter into an HP agreement without defaulting, because there are serious implications.
It's a very important point that you've said that if you've bought anything on hire purchase, you do not own it.
You do not own it.
Ownership passes to you at the end of the last installment.
Yes.
So if you default, it doesn't matter that you've paid 50,
Or
80% or 90%.
You don't own
you
it.
default the last month, that's it. So you don't own it, the property can be repossessed. That's the risk. That is why sometimes it's better to buy cash, to save and buy cash if
Or
you can.
lay-by.
Or lay-by.
Yeah.
Okay, sure. You wanted to come in there?
Your Excellency, I think what is also important is to take into account what is the interest that will be spread over the duration of the hire purchase agreement. Because that tells you, in most instances, because of the risk of you purchasing, is that the company or the financer of the asset would protect their interest in the event that you default.
Yes.
But you also need to know what are the consequences in the event that you do default. In certain instances, the full amount becomes due, and they may even repossess, in light of what you said, is your Excellency. But they realize the asset at a reduced, because it's a quick sale to realize the asset. It has depreciated in value, etc. And the balance of that amount that is still owing, that might be your liability still. So the repossession of that asset does not entirely absorb you from the rest of the liability. Yes.
Yeah. So they may repossess the property,
Yes.
and you may still have to pay
Yes.
what you are owing.
The balance, so they will realize it,
Yes,
and whatever they realize, if there's an amount that is still owing, you'd have to settle that cost.
What about the bond? People buy properties, houses through a bond. Is the same principle applicable, or is it different?
It is the same principle still applicable. However, there are laws that protect the auctioning of the house, because it is, particularly if it's a primary resident home, where you have to follow the legal process of summons and an attachment of that. But the courts are very reluctant of really allowing either a bank to realize the immovable property, because there are certain, under the Constitution, you have a right to housing and whatnot. So the financial institution has to prove that if we realize this asset because we want to realize our rights under the contract, these people have a backup or an alternative means of accommodation if we do sell the asset.
But we've seen many houses get repossessed when people have defaulted.
Yes.
After they've paid for 10 years, 15 years, and then they fall on hard times, and then the house is attached.
There are protections that have been allowed by law in order to protect particularly those instances. And obviously, even when the asset has been exhausted or the individuals couldn't fight the legal action due to costs,
Yes.
the eviction process still is a protection insofar as you being removed in that house.
Yeah.
It may be sold, but you being removed, whoever is applying for eviction has to prove certain elements of an eviction order. But that is a discussion for another day.
Yes, correct. You want to come in on the partnership agreements, the implications? You are lawyers. Lawyers get into partnerships agreement, doctors, engineers. What are the implications of those agreements?
I think the main implication of a partnership agreement is everybody within the partnership is jointly and severally liable. It's not a separate legal entity like a company.
Jointly and severally liable.
Yes.
Can you explain that?
Okay, so what that means is any debts within the partnership, it doesn't matter which partner signed for it. Should any creditor come and enforce their rights, the entire partnership is liable, including if you are married in community or property and you have your own separate estate outside of the partnership, that will also be held liable. So it means you're liable within the partnership and severally on your own as well. So that is...
I understand that. So
yes.
if one of the partners or two of the partners in say a law firm that has 20 partners, are married in community of property, their wives have to sign suretyship or sign together if the partnership enters into some agreement. So those spouses are now going to be joined if anything goes wrong in the partnership.
If anything goes wrong, yes. So you basically join within the partnership jointly and severally in your own personal capacity. And obviously in your own personal capacity, if you are married, then in community or property,
your spouses get
so then
dragged into
that will all be dragged into one.
Alex, you want to come in here?
Yes, if I can just quickly respond to something that my colleague there said. When a house is attached, you have to go and make sure that the judgment that was not taken by the registrar, and that it was actually done by a judge, because it has been held in our courts in South Africa that a registrar cannot give a judgment that can be executed upon, especially in the case of a primary residence, as you have stated. So go and check that carefully. You might have recourse, even if that judgment was taken 3 years ago, because that judgment is not a valid judgment.
That's a very good point.
Yeah, so as far as the partnerships are concerned, you can enter a partnership agreement, preferably should be in writing. It can contain any of the elements of a normal contract. I think it's important to state who will be entitled to what profits, who will be liable to what contributions, how the partnership will be dissolved. Normally, if a partner resigns, there's an automatic dissolution of the partnership. You will find sometimes you will get a partnership of incorporated companies, which is more of commercial type of structures. But in order to regulate it properly, it's best that it be in writing and that it's signed by all the partners.
That's very important. So the people out there who are in partnerships need to consult legal advisors and help them draft a partnership agreement.
Absolutely.
Now, many people enter into joint venture agreements when they pursue business opportunities. And what are joint venture agreements?
A fantastic opportunity to put something together to see if you can work together in the future, and that normally regulates the future then.
So the joint venture company is separate from either party's companies, and the assets and the liabilities of the joint venture of that SPV belong to that SPV. So if I enter into joint venture with you, our companies, and my company is not bound by the liabilities of a joint venture. It's separate. It's a separate entity from the joint venture.
It is absolutely correct. It's a separate venture. There's important clauses in the Companies Act that becomes applicable if one company wants to stand surety for another. So you would have to carefully go and look at, for instance, Section 226 of the Companies Act, and comply with those terms before you can stand as a surety for one company for another company. But normally what companies will do is they will use it as you said, a special purpose vehicle, which is what SPV stands for, and they will conduct their business in that separate company.
Okay. We've got 2 minutes to wind up this segment. Maybe who wants to take it? Okay, 1 minute, 1 minute. Okay, you can take the 2 minutes and we'll start with you in the next segment.
Well, I would like us to look into the nature of suretyship, because it's one of the legal ways of guaranteeing maybe in a transaction that...
Just hold in there. We'll talk about suretyship in the next segment. Maybe I should give to you the point you wanted to make.
On the joint venture
on joint ventures.
I think that joint venture has become a terminology utilized a lot in small and medium businesses. And that is because we don't want to tie in our liabilities, and as my colleague alluded. However, in most instances, it's particularly if we want to partner in executing a task. Some are incorporated, which form in a company. Some are unincorporated, which can be purely regulated by an agreement, and in most instances referred to as a joint venture agreement. And in that joint venture agreement, we can even open a bank account, which to say we will execute this as independent individuals, But under this agreement, we'll execute that, and should the proceeds be paid out, they will be paid into a joint venture account, then spread as individuals, and we can then go our separate ways. That agreement would normally regulate our obligations and participation as independent individuals, and what are the profit splits, and what are, you know, various interaction terms that we want to record. So that's what in most small and medium businesses, particularly lately, enter into.
We are now winding up our discussion. But before we wind up our discussion, we want to look into the special kinds of contracts that people do. When people buy businesses or buy shares in companies, they enter into loan agreements and even buying any form of assets. What is it that people have to look at when they enter into these kinds of funding agreements or loan agreements? And most of them are accompanied by suretyship agreements, session agreements, and pledge agreements, and all that kind of thing. So what are the implications of signing those kinds of agreements? And can people get out of those agreements if things go wrong or they are stuck with those agreements? Who wants to start?
Well,
Alex?
no. Well, ladies first.
Ladies first. Okay.
Systems have changed, no anymore. I think loan agreements are, what do you look for in a loan agreement? I think it's important that you determine what is the quantum that you're loaning for and what is the interest. And I've repeated myself on this, but also what is default interest in the event that you have defaulted in payment. It's important to also identify what are the payment terms of when you take the financing, what are the payment terms. A lot of the loan agreements have what is called warranties, representation, and undertakings. And those say that I warrant that I have not been blacklisted. I warrant that I did not do this. And I further undertake that I will not be blacklisted and whatnot. What happens is at a later date, should you breach that or go against those warranties that you've given in the loan agreement, you run the risk that they will pull and that will be in breach. And you need to know what happens when you are in breach of a loan agreement. So a lot of times people do not pay attention on those warranties because you wake up one day, you are blacklisted, you wake up one day, you've defaulted on those warranties or you've defaulted on the payment. But I just thought, I'm happy to...
No, that's very important points that you're looking to. That it's important to look into those warranties that you sign, that if you breach them, then you are in trouble. But that's applicable when you sign those agreements as a person, as a natural person in your individual capacity. What happens if you sign, for instance, if companies enter into loan agreements, normally directors or shareholders are required to sign suretyships. In other words, if the company defaults, you have to stand in, as a shareholder or as a make good for what the funder may lose. What are the implications of those? And especially also if you merit in community of property.
Well, if I can respond to that, firstly, I just want to quickly pick up on what you said. You will find often, and I agree with what my colleague said, you will find often that in a sale of business agreement, as that you've mentioned, you will find that there's a lot of warranties that you have to comply with. You have to be very careful with those when you sell a business or when you sell the shares in a business, because normally you will be required to state that there's no litigation, that your tax has been paid up, that your financials are in order. And when you give a warranty, you must understand that you warrant that what you are saying is true and correct, whether or not it is true and correct. So you've got to be very careful. And another point I think I need to make that's very important is you have to realize that you now have a bit more negotiating power with the Consumer Protection Act that we haven't touched upon. You are entitled to negotiate your contract. So go and look at it, chop it, change it, delete things, participate in it. It's your duty to make sure that you just don't sign whatever is presented for you. And just to get back to your question, you've got to be very careful when you sign a suretyship agreement. The banks love those stuff. They will drag you around in court for years. I've seen cases where a suretyship has not been signed separately, and the person who signed it was exonerated by the court. He was not held liable because it wasn't signed separately. But also, when you sign a suretyship, go make sure that you limit it to the amount that you are lending. Don't sign an unlimited suretyship.
Yes. Yeah.
Make sure that you that if you lend 10,000 Rand, that you limit that suretyship to that amount, and so that there's no cross-pollination of sorts.
Correct. Nadia, do you want to come in here?
Yes, Your Excellency. I also just want to touch on your point. You asked what happens to directors that sign surety and their spouses at home. If the director is signing within the course of his business, and so basically at the end of the day, he needs to make sure he's signing within the course of his business and not in his own personal name. If he's signing surety in his own personal name for a house, then yes, the consent of his spouse is needed with 2 other witnesses. If he is a director of a company and signing within the course of business, then his spouse's consent will not be needed because he's signing as an agent for his company.
Okay. Your Excellency, you want to come in here?
Yes, Your Excellency. I think one other important thing before you consider whether or not to sign a suretyship, the character of the person, their business, how they conduct their business, you should look into that. Do your due diligence, because there is no guarantee how they will behave down the line. Yeah. So it's very important to take that into account before committing to a suretyship.
That's a very, very, very important. Thank you very much for your inputs. We are now wrapping up. I'm going to give you now 1 minute each to make your concluding remarks, your final advice to the viewers there at home. Alex, do you want to start?
Thank you. Well, a contract is really a very simple thing. You need to understand what is written there, and if you don't, simply go and take some advice. Don't sign when it is presented to you. Say I first want to go and read it. You have that right in terms of the Consumer Protection Act anyway. Go and read the Consumer Protection Act. It gives you a lot of rights which you did not have before. It protects you. It says that you are entitled to receive goods which are working as they should work. Leases are subject to the Consumer Protection Act. When minors enter into contracts, they are protected by the Consumer Protection Act. Go look at section 37, 39. When you receive defective products, we acted for a client who went to a company. He used a hand pump. He wanted to buy an air rifle. It dislodged the gauge, shot out his eye. We got an order in the High Court in Pretoria recently for about, I think the quantum is about 12 million Rand now. And we pursued the importer and we pursued the supplier of that product. And in terms of the Consumer Protection Act, and the Act says that you are entitled to goods which work properly. So go and read that Act. Take the time when you enter into a loan agreement, use Google, go look at the National Credit Act. There's a lot of protection there for you. Make use of it.
If you don't understand, you consult your lawyer before you sign any agreement. I would think so.
Yes.
Your Excellency.
Thank you, Excellency. I think it's very important that before signing, you really consider all your rights and responsibilities, especially read through the contract, because rights and responsibilities normally are not in just one section. They are spread out through the entire contract, yes. And also, it helps you to make a decision whether it is the right thing for you to do at that point in time to get into that contract. In any case, even if you have no choice, you are in a desperate situation, it's always good to sign up knowing exactly what you're signing up for.
Exactly. Nadia?
My advice to you is also always look at the exit clauses, look at cancellation clauses, look at breach of contract. What happens if you breach the contract? How do I get myself out of the contract? And also sunset clauses. Sometimes contracts have clauses that renew the contract automatically. If you don't terminate it within a certain period of time, you'll find yourself tied to the contract for another year, another 2 years. So besides understanding it, I think look at how do I get out, or how do I protect myself should I default or should anything go wrong.
Okay. Your final input, Madam Yolisa.
Thank you, Excellency. I think all I can say is do not be afraid to take risky steps and enter into those difficult and tricky contracts, provided you know what could possibly go wrong.
So, but you must prepare yourself for
Absolutely.
what can go wrong.
So, absolutely.
Thank you very much. I think we had a very fantastic panel, and we got a lot of advice from you. We appreciate the advice you gave to us and the viewers, and I really would like to thank you very much. And to the viewers at home, thank you for tuning in, and I'm sure you found the information quite useful. Should you need any more information, you can join us into our website at www.globalbusinessroundtable.com, or you may also email us at comments@anewthing.tv, comments@anewthing.tv. Remember at all times to seek first the kingdom of God and his righteousness. All these things shall be added unto you. Matthew 6, verse 33. See you again next time. God bless.